Thank you. Thank you very much, Mr. Bonucci. Well, I wish to thank Charlotte, of course, for this event and for giving me the opportunity to be a part of it. I'd like to thank, of course, Catherine Botoko and Fatim Deli, who made this conference happen today in Paris 1. And as well, I'm very grateful to Lisa Hertz, Estelle Richevillin, Juliana Marino, and Paul Eckler, which are PhD students here in Paris 1, for helping us the way they did. So I believe that we are here at a crossroad between today's topic on state practice and its validity and tomorrow's on economic actors' practice. Unfortunately, the title of this contribution on the flaws of contemporary blocking statutes and regulations cannot but introduce a very pessimistic outlook on the efficacy of contemporary blocking statutes and regulations. Well, we could distinguish two main categories of flaws. First, their inability to protect their primary recipients, so domestic natural persons and legal persons, from the extension of a foreign state enforcement jurisdiction. So I will principally address this issue. Second, their very limited scope as far as tackling the issue of extraterritoriality is concerned, because blocking statutes express an opposition to a certain foreign behavior but do not tackle the underlying normative issues behind them. So I believe I will speak without this microphone, which won't really work, but if you hear me well, I believe it will be fine. Or perhaps this one works. Yeah, I will try that. So this contribution is not meant to address these underlying normative issues, which have already been discussed today and will be discussed tomorrow, so I won't take the risk to extend the scope of this contribution and be blocked myself. Nevertheless, I will have a few final words on the true utility of blocking statutes. So first, what is a blocking statute or regulation? Well, it is a domestic normative act whose role consists in neutralizing the alleged undue scope of a foreign law extending the enforcement jurisdiction of a state beyond any reasonable point. So the blocking statute compels domestic companies, individuals or administrations to disregard such a foreign law and to act in accordance with domestic regulations. So as such, blocking statutes can answer to a variety of foreign states' conduct. First and foremost, of course, foreign injunctions aimed at domestic operators to transfer data in corruption and tax compliance matters. This is the case of the FATCA or the FCPA. I won't really address these issues. I will address a second kind of conduct, which are foreign injunctions on domestic operators to apply their trade and financial restrictions on third states. So, the doctrine has now long talked of the dilemma or catch-22 situation which results from these competing obligations on the recipients of these laws. Basically, complying with either one or the other legislation could result in being sanctioned under either one of them as well. However, the veracity of such a dilemma rests on the premise that blocking statutes are structurally efficient on their recipients, and yet the European financial sector keeps applying American foreign injunctions, and recent case law even begin to demonstrate that European jurisdictions could confirm the annulment of contractual business relations with an Iranian entity despite of the EU blocking regulation. So apparently the real dilemma does not really rest on the recipients of these competing laws, but on states themselves, on the blocking states themselves. To put it colloquially, where do they really want to go with blocking statutes aimed at extraterritorial sanction regimes? So for this purpose, I will divide this presentation according to the two main categories of tools that blocking statutes may provide. The first category is mobilized upstream the imposition of a secondary sanction by the foreign state, let's say the United States. These tools aim to forbid domestic operators to comply with the foreign law. That's the first tool. And, as the case may be, sanction them for their non-compliance. That's the second tool. The second category is deployed downstream the imposition of a secondary sanction, that is to say, where the first one did not work. so as to protect domestic operators from the already existing consequences of the extraterritorial rules. So it is first the absence of recognition and enforcement of any foreign secondary sanctions, so that's tool number 3, and finally, as a last resort, the possibility to perhaps recover damages for the harm caused, which is tool number 4. So, with regard to the most important one, the non-recognition of extraterritorial sanctions and the prohibition to comply with them. I'll be a bit longer with this one. As far as private international law is concerned, blocking statutes set compulsory rules of conflict of laws which are deemed to be perfectly valid and falling in the sphere of autonomous display of states' competencies. So, in theory, a blocking statute does not grant any choice of law. For public policy reasons, ordre public, it has to be applied and enforced as part of the lex fori. Yet, well, that's in theory. And a very important foreign policy discretion does apply in this matter. It applies with regard to its content, the content of blocking statutes, and it is true as well of its interpretation. So first, we can say that blocking statutes usually do not apply to any extraterritorial law. They usually empower an enforcement authority to adopt completely discretionary delegated acts through which a specific foreign law, which is deemed to have an extraterritorial nature, shall be neutralized in accordance with the blocking statutes. So, as such, for instance, it is worth noting that the Attorney General of Canada, with regards to the Canadian blocking statutes, well, did not follow the European Union Commission as regards the reimposition of Iranian sanctions in 2018. Moreover, even as far as the European Union is concerned, we can notice that the Countering America's Adversaries Through Sanctions Act, which has been adopted in 2017, is not included as well in the EU blocking statute itself. And yet, it has extraterritorial effects, and it does target Iran as well, but also Russia, Ukraine, North Korea, over which the European Union aligned. So there are no logics of systematicity here. Well, there is one exception, if we could talk of exceptions, because there is a very small number of blocking statutes in this regard, but the Mexican blocking statute from 1996, which I won't pronounce the name in Spanish, I'm sorry, does apply to any extraterritorial law as long as it fits in the definition given in its Article 1. So as such, it is up to the recipients of this law to interpret whether or not a foreign law may or may not fall in its scope. Moreover, this Mexican blocking statute does not foresee any exception regime, and nor does the Canadian one, but the scope of the Canadian blocking statute is extremely limited because it's only the Helms-Burton Act over Cuba sanctions and the Buy America provisions concerning trade between Alaska and Canada. Unlike them, the EU blocking statute does provide for exceptions. Article 5, paragraph 2 of this EU blocking statute empowers the European Commission to grant an exception to comply if any entity demonstrates that non-compliance would seriously damage its interest or those of the community. Unfortunately, there are no public information whatsoever on the number of demands and actual exemption granted. Also, as we shall see later, this point is absolutely crucial with regard to the perception of the blocking statute by the US authority. Secondly, the most recent case law demonstrates that even when a blocked foreign law is at stake, the injunction not to comply with this law can be interpreted very flexibly by domestic courts with a very important deference for domestic companies, and notably when such companies comply through a sanction clause in a contract with a US company facing legitimate sanctions. So I only briefly mention two cases without overtaking on Marjorie Echo's clause and sanction clauses. The first one is the Maman Cochet Mining versus Aegis Managing Agency case, which has been adjudged by the High Court of England in October 2018. It involved two British companies. The claimant got marine cargo insurance from the defendant for the shipment of 2 cargoes of steel carried from Russia to Iran in 2012. Then the goods were stolen, and the assured party, the claimant, made a claim under the contract because the defendant resisted payment on the basis of this sanction clause. Well, obviously, this sanction clause was deemed to be valid for the reasons that Marjorie will develop, but considering, of course, that the EU blocking statute was inapplicable ratio temporis because it was in 2012. But still, the court answered the point of the defendant over this blocking statute and stated as an obiter that the blocking regulation was not engaged anyways where the insurer's liability to pay a claim was suspended under a sanction clause such as the one in the policy. And why? Because in such a case, the insurer was not complying with the third country's prohibition, but was simply relying upon the terms of the policy to resist payment. So he had a free choice. Another case, which was delivered in October 2018 by the Regional Court of Hamburg in Germany, refers to acts which are posterior to the blocking statutes and casts as well real doubts on the applicability of the EU blocking statutes to contractual situations. Here, the claimant was an Iranian shipping company having a bank account in a German bank. In 2017, the German bank kept refusing to execute any payment abroad from this company, and the company sought an interim relief to the District Court of Hamburg so as to compel the bank to maintain the bank account open, at least until it could find another EU bank. It was denied, and subsequently the bank terminated the contractual relation on August 31st, 2018, which means after the entry into force of the updated EU statutes and after the end of the relevant wind-down period for the reinstallment of the US sanctions on Iran. Here, the Regional Court of Hamburg found that the bank had a valid ground as well to terminate the contract, considering its risk to face secondary sanctions, and that in any case, no corresponding banks in the US would agree to cooperate with such a client, so the ground was actually valid. So as such, it was deemed that the bank did not violate the EU blocking statute, but merely decided freely and on a lawful ground to terminate the contract. So such an interpretation of the blocking statute, which is based on a risk-based approach, seems to contradict the very core of the blocking statute. In this line, we can only hope that preliminary questions will soon be asked to the European Court of Justice for the interpretation of Article 5 of this EU blocking statutes, which imposes not to comply directly or indirectly with the requirements or prohibitions resulting from these laws. Finally, on a different line of argumentation, regulatory authorities themselves may encourage the financial sector to take notice of the content of US sanctions regimes despite this obligation not to comply. Why? Because it helps the financial sector to meet their anti-money laundering and financing of terrorism requirements. It is quite clear from the last guidelines from the ACPR, which is the French Banking Supervisory Authority, which are from June 2019, that, and I quote, irrespective of the implementation of domestic and European asset freezing measures, the measures drafted by other states may constitute elements of information enabling financial operators to feed their databases for their KYC requirements and the implementation of AML-FT obligations. So in other words, if one does not comply with the US sanctions on Iran, it might be liable for violation of the bank's AML-FT requirements. So there is much to think that in this situation as well, we are not within the obligation not to comply, which is enshrined in Article 5 of the EU blocking statute. So, the more flexible the interpretation of the blocking statute can be, obviously the less agreeable the US courts will react when assessing whether or not a company was actually bound or not by a conflicting obligation. Indeed, as part of the foreign sovereign compulsion principle, which US courts apply out of committee, US agencies and courts could take into account the absence of any real dilemma into account. Moreover, such a flexibility can cast as well legitimate doubts on the willingness of the blocking states to sanction the breaches of the blocking statutes. That's tool number 2, and I'll be much quicker. Blocking statutes contain a sanction mechanism if any of its recipients violates it. Nevertheless, as it was just seen, this hypothesis of violations may not be that frequent. And moreover, we could very hardly find any administrative or criminal proceedings actually leading to such a sanction. But well, still, the blocking statutes of Canada, Mexico, and soon Russia are good examples of extra-EU countries where an appropriate sanction mechanism exists. Okay? In Canada, there can be a fine of 1.5 million Canadian dollars, and an individual can be liable of an imprisonment for up to 5 years. In Russia, as well, there could be a criminal liability of up to 4 years of imprisonment, but this law has not yet been adopted. As far as the EU blocking statute is concerned, its Article 9 states as well an obligation for member states to determine the sanctions to be imposed. But the problem is that not that many EU states took those legislation in order to criminalize such conduct, or not even criminalize, but fine such conduct. So we could quote Ireland, which has such a mechanism, Belgium as well, Germany, but for instance, the French blocking statute, as it stands, does not apply at all to foreign sanction regimes, and neither do other EU states. So, well, there are serious concerns about the ability of blocking statutes to reach their primary objectives. Obviously, it would be naive to think that a systematic efficacy was foreseen by their drafters, but still, such flaws leave domestic operators very vulnerable, and that's one of the reasons why blocking statutes do provide for other kind of remedies for the injured domestic operators. First, so that's tool number 3, by not recognizing or not enforcing any secondary sanction. Every blocking statute prohibits the recognition or any exequatur proceedings of foreign secondary sanctions. So theoretically, the affected operator could move away from any monetary fine or conviction on a specific performance order, but obviously here again, such mechanism does not tackle the economic privilege of the United States, which makes it likely that the operator complies willingly, considering the operational risk that he faces in the US. So, various recent cases demonstrate that recognition or exequatur is completely unnecessary every time that a settlement procedure enables the OFAC to recover directly from the sanctioned operator. So, as far as OFAC and Iranian sanctions only are concerned, the British bank Standard Chartered settled in April 2019 for a total of $640 million. Unicredit Germany, Austria and Italy in April 2019 as well for a total of $1.3 billion, and Société Générale in November 2018 for $54 million to OFAC, but $325 million to the New York State Department of Financial Services. And all of these settlements include a list of sanction compliance commitments. So it is common sense that these worldwide corporations are not going to rely on the fact that these fines won't get exequatured in Europe, because they have too much to lose in the US. Worse, and this is my last tool, my last point, the affected operator will not be able to recover any damages caused by a United States agency, even though blocking statutes provide for clawback mechanism. So the clawback mechanism enables the injured person to recover damages through a civil action arising out either of unjust enrichment or a tort. And it may be found, for instance, in Article 6 of the EU blocking statutes. Well, the first point in this is that when the damages are caused by US agencies imposing financial sanctions, such clawback actions would amount to recognize the liability of the United States for acts committed in the exercise of state authority, so acta iure imperi. So blocking statutes do not create any exceptions to the immunity of jurisdiction or execution, and actually quite the contrary, because the EU blocking statute, for instance, relies on the recast Brussels I regulation of 2012 for this purpose, which specifically excludes from its scope the liability of the state for de jure imperi acts. Moreover, and in any case, any such proceedings would contradict the rules of customary public international law as they stand. Well, on this point, we could say that considering how the United States legislation extended beyond any imaginable reasonableness reach of the exception to the immunity of jurisdiction and execution with regards to Iran, perhaps EU jurisdiction should do the same. But that would amount to a countermeasure, which is inherently unlawful, and this is absolutely not the purpose of the blocking statutes. So, as such, actions for the recovery of damages could only be directed at a private party in an action in damages for non-contractual obligations. So, for any losses which were caused through the application of the foreign law. And here again, there is a problem, perhaps, because the EU rules on choices of law in non-contractual matters, which are governed by the Rome II regulations, well, if we apply them in many scenarios, the damage will be deemed to occur in the United States, so that the claim will be subject to the law of the United States and thus be dismissed. So, as such, EU courts would have to acknowledge that the clawback provision is an overriding mandatory provision, and we can only hope that the European Court of Justice will have the occasion to interpret the blocking regulation. So, to conclude on this topic, there is a structural inability, perhaps, of blocking statutes to provide legal certainty, but it could be described actually as a mere flexibility. The tools exist, but the political choices, may render those EU blocking statutes ineffective. But yet, the most effective feature and success of blocking statutes, because there are success as well, lies in their legal value as far as public international law is concerned, because they constitute a critically important element of state practice, because they express a stance on the opposition to the American extraterritoriality. So as such, they set out milestones which crystallize a legal dispute, which is a crucial element here for its settlement. So as such, blocking statutes carry on a significant weight for current or upcoming international litigations, for hypothetical recourse to an advisory opinion of the ICJ, for instance, or potential upcoming works at the international law commissions, or for the negotiation of potential multilateral remedies that Lena will address now. Thank you very much.